So now that we understand the importance of managing risk, we can now move on to part 2, which goes into more detail around legal requirements, the sentencing guidelines, and corporate homicide and corporate manslaughter. One thing I would say is that generally, if you're managing health and safety effectively, as directors, you have very little to be concerned about. The whole purpose of part 2 is to look at what the law actually requires so that you're aware, and so you're aware of your duties as directors and those accountable within the business, so that you can ensure that you do have very little to be concerned about. So let's look at the law in a bit more detail. So when it comes to health and safety, everything starts with the Health and Safety at Work Act. So the Health and Safety at Work Act is an umbrella piece of legislation from which all other types of regulations are produced. And we're going to a little bit of detail around what the Health and Safety at Work Act says, but in a very small nutshell, it asks that any employer ensure the health, safety and welfare of the employees whilst at work. And that duty also extends beyond employees. It covers members of the public, visitors, contractors, basically anyone who can come into contact with the risks that you pose as part of your work. So the Health and Safety at Work Act is very broad, but what it doesn't do is it doesn't give us the legal framework for other topics within health and safety. So that's where we have regulations that cover those topics. So for example, when we look at hazardous substances that we may use, we have the Control of Substances Hazardous to Health regulations to cover that. And they all stem from the Health and Safety at Work Act. They all stem back to that legal duty to make sure that health and safety is being maintained whilst at work. Whenever a piece of regulation is passed, there will be an approved code of practice that is published alongside it. That approved code of practice will break down what the regulations is saying into perhaps a more understandable version for employers, and it looks at how the law can be interpreted to ensure that employers can prove that they're doing everything in accordance with the Health and Safety at Work Act. A lot of the time, approved codes of practice also get supported with guidance documents, and these can usually be obtained from the Health and Safety Executive or the HSE's website. So you would first identify what area of regulation that you're looking for, and then identify if there's a code of practice to support that regulation, and the guidance that sits alongside it. So what does this mean in terms of a legal setting? Well, there are a few key terms within health and safety law that provide a level of statutory duty. So any health and safety regulation, there is an absolute duty to comply. So if a regulation says that you need to have a risk assessment and you don't, then you have breached that legislation. So it's an absolute duty. There's no discretion. The discretion comes in when we start to assess risk, and we should be looking to implement health and safety measures to manage risk within best practicable means, and those precautions should reduce the level of risk as far as reasonably practicable. And those three terms are used a lot. And you may be asking, well, okay, what is as far as reasonably practicable? So how you go about demonstrating that is, well, if you can say, well, for the area of health and safety that is a risk to our business, we've looked at the code of practice, we've implemented it as much as we possibly can, and also any guidance. If you follow guidance and good practice, you are then able to highlight where you are doing so far as reasonably practicable. It also be recommended that if there's any good practice within the industry that you work in, that should also be considered for implementation to reduce risk so far as reasonably practicable. Failure to comply with any piece of health and safety law could result in either criminal action or civil action, and we'll be talking a little bit more about both these elements as part of this session in the training. One thing to mention is that a breach of health and safety law is enforceable by both the health and safety executive and local authority environmental health. So both enforce the same regulations in the same way. They have exactly the same powers, but typically they just enforce in different industries. So your health and safety executive is typically in your higher risk industries, your constructions, your manufacturing, your engineering, whereas your environmental health are typically more like your vehicle repair, restaurants, hotels, offices. Both enforce health and safety. The only time the HSE would step in above an environmental health officer would be if there was a fatality. But they both enforce health and safety law, and they're the ones who would take action if you weren't complying. So let's talk about the Health and Safety at Work Act in a little bit more detail. So the Health and Safety at Work Act, introduced in 1974, places duty on three elements: the organisation as a whole in terms of the employer, senior managers and directors, and employees. And we'll be talking a little bit more about those as well as we go through. So let's take each of those in turn and delve into those duties in a bit more detail. The organisation. So as far as reasonably practicable, there's that term again, the organisation should ensure that there is a provision of the following. So they should be ensuring that within the workplace, you have equipment and plant that is safe, not just safe upon purchase, but is maintained in a safe condition and safe for use. So we have to make sure that that's in place. Where those plants and equipment are used by employees, it is important that the organisation has safe systems of work in place. A lot of organisations will see a safe system of work starting and ending with a risk assessment. A risk assessment is only the start of a safe system of work. A safe system of work starts with a risk assessment in terms of identifying the risk. But what is important is that that risk assessment doesn't then just sit on a shelf, gathering dust, that we communicate that risk assessment to those who could be affected, and that we then check that that risk assessment is being followed and we enforce the precautions that are outlined in it. And obviously anything that's not working, we go in, we review the risk assessment and the circle continues. That is what a safe system of work is. Any enforcement officer will be looking to see, have you got a safe system of work in place? That's what they'll be looking for. Do people know what they should be doing to work safely? Do they know what the risk assessment says? A piece of paper in terms of a risk assessment is only going to give you so much protection, possibly from an insurance perspective. From an enforcement and a legal compliance perspective, it's important that it is evident that safe system of work is happening in practice. Okay, so that's what a safe system of work is. The organisation also has to make sure that there's a safe workplace, and that includes safe means of getting in and out. So that's when we start to look at things like fire exits and obviously the condition of any access and egress points. We have to then make sure that the environment in which people work is safe and again doesn't put anyone at any adverse risk to their health or their safety. The law also says that we have to provide information, instruction, training and supervision, again because everyone has a part to play when it comes to health and safety. So we have to inform people of what the risks are, instruct them on what they should be doing to keep themselves and others safe. And that may involve some extra forms of training and then making sure that they're supervised to make sure that they're following those instructions and acting in a way that they have been trained. And then the final legal duty is that any organisation should have a health and safety policy. Any organisation that employs 5 or more employees should have a written health and safety policy. So in a very broad sense, that's the legal duties of the organisation. So just have a think for a second, and as an organisation, are you able to hand on heart know that you have safe plant and equipment, safe systems of work, a safe workplace, safe working environment? Do we provide information, instruction, training and supervision? And do you have a written health and safety policy? Moving on. So we've mentioned that directors and senior managers, basically those who have responsibilities for influencing how the work is carried out, they have a legal duty as well as the organisation. So if it's identified that an organisation is in breach of its legal duties, so for example, it didn't have a safe system of work, there wasn't a safe workplace, people weren't appropriately trained or provide any information, instruction or supervision. Let's just say that one of those legal duties for the organisation has been breached. Where a director or senior manager comes in is where that breach has occurred through either consent, connivance or neglect. Then in addition to prosecuting the organisation, then a director or senior manager can also be criminally liable. Okay, so let's just talk about those three terms: consent, connivance and neglect. And let's just talk about what they mean in terms of a behaviour from a director or senior manager. So consent, that is basically where someone has been allowed to work in a way that has been consent given by a manager, by a director. So that person has been allowed to work in a way that's unsafe. Connivance, we see this quite a lot. So my background is in enforcement, and this is one of the things that we saw quite a bit, especially when you start interviewing members of staff after an accident. You soon find out what role senior management and directors play when it comes to health and safety. So sorry, connivance is there's a knowing to an unsafe act and a willingness to secretly allow or be involved in an immoral or an illegal act. That's what connivance is. So a good example of that is, I know you're not meant to use that ladder because it's not tall enough, but I haven't seen you using it. So with acknowledging that it isn't necessarily safe, or that the processes in place isn't necessarily perfect or is going to protect that person, we aren't doing what's reasonably practicable, but we'll take a risk. I haven't seen it. Okay, so that's what connivance is. And then neglect is purely disregard. So perhaps there's been expressed concerns from staff about health and safety, but the organisation has done nothing about it. It's been neglectful and has deliberately and unknowingly put people at risk, and they've neglected their duties in terms of health and safety. So if a manager or director is linked to a breach through consent, connivance or neglect, then they can be held criminally liable as well. If that person is also a director, then they can also be disqualified. So if a breach leads to prosecution and a director is found to be criminally liable, either through consent, connivance or neglect, then they can be disqualified as a director for up to 15 years. And they would be classed as unfit to act as a director. And unfit conduct then doesn't allow you to be involved in any form of promotion, formation or management of a company, any other company, not necessarily the one that that director is currently a director of. So it does have a major impact because it could create financial implications and earning potential for that person. So it does have a lot of implications for the individual. So a couple of other things that it may impact on is, as a director, some directors may sit on the board of a charity, school, police authority. They might be a trustee for pensions. They might be a registered social landlord. They may sit on health board or social care body, or they may be a solicitor, barrister or accountant. If you're disqualified as a director, you would also be disqualified from all of those things as well. So other potential activities of that director would be restricted, and that disqualification can be made for up to 15 years. I've mentioned about directors and senior managers being held personally liable, and we're definitely seeing that where an enforcing officer can create evidence, find evidence that a director or senior manager has breached their duties and has had some hand in that, then there is a focus for enforcing officers to hone in on it. So to scrutinise everything. So not just looking at the accident or an incident or breach in isolation, looking at the corporate body and looking at, okay, what's management's role in this? And we're definitely seeing higher sentences being imposed for any individual prosecutions, as well as corporate prosecutions as well. It's increasingly likely that a director could go to prison, not only when breaches are intentional, but also where there's that flagrant disregard or blind eye. So that's that connivance coming in. So that's important to remember. So we've looked at the legal duties for the corporate body, the organisation. We've looked at it from a directors and senior management point of view. Let's just look at it from an employee's element. Okay, so the Health and Safety at Work Act does stipulate duties for employees. So what is important that, yes, the employer must make sure that health and safety is in place and that people's health and safety isn't put at risk, people go home in one piece at the end of the day, but employees have a duty as well. Okay, and these are very straightforward, but you'd be surprised, especially in the event of an accident, where one of these or more than one of these plays a part, especially where there's been an input by an employee. So the Health and Safety at Work Act says that an employee must take reasonable care for their own health and safety, and they must also take care for the health and safety of others. So they shouldn't do something that puts someone else in harm's way. They should cooperate with the organisation. So if you're asking someone to go on a training course or a refresher training and they refuse to go, they're not cooperating. If you've implemented a new procedure or a new safe system of work and they're not following that procedure, they're not cooperating. And it's a legal duty that they must do so. They must not recklessly interfere with or misuse anything provided in the interest of health and safety. So that's your horseplay stuff. That's where equipment is rode around on instead of being operated properly, for example. They must as well behave in a manner in which they've been instructed and trained. So if we've advised them that as part of training, this is how you should work safely, if they go against that, then they are failing in their employee duties. Okay, sounds very straightforward. But with my background in enforcement and since being a consultant, human stupidity doesn't cease to amaze me anymore. So people's perception of health and safety is very different across the board. And people take risks, especially if they're up against it. They may feel they're doing the best for the organisation, but it is important that employees understand they have a part to play and they must not fail in their duties. Give you a good example. Doesn't happen very often, but does happen. So in February 2018, this incident happened. So this photograph was taken by an ex-enforcement officer, just happened to be in a surrounding building. And what you can see is a scaffolder and his apprentice working off scaffolding, working at height, in fact, 18 meters above the ground. And as you can see, this gentleman here is working without any guardrails or safety rails to prevent him from falling. No, he's not clipped on, there's no scaff step process, and underneath here is his apprentice. So, ex-enforcement officer takes a photograph of this. The incident actually happened in Manchester. Took a photograph of this and sent it to his local HSE office. HSE investigated and identified that the organisation had trained that person. They were qualified scaffolder. There was safe systems in place for erection of scaffolding, and that actually they were able to prove that this employee had not taken reasonable care, not only for himself, but he was setting an example for his employee and his apprentice beneath. And he certainly didn't behave in a manner in which they were instructed and trained. So he had been trained, he was a qualified scaffolder, so all the things that he had learned in his training, he had gone against. And the organisation was able to prove, here's this person's training record, here's our risk assessment, here's our method statement. And they were able to prove that that person acted alone against his better judgment and training to work without edge protection and safety measures in place. So what happens in that situation? The employer and the organisation isn't at fault because they've done everything that's reasonably practicable here. They've complied with the law. So the HSE goes after the individual and they prosecute the individual. So the scaffolder was given a 26-week suspended prison sentence, was ordered to complete 100 hours of community service, and was required to pay a fine of £615. It doesn't happen very often, but employees can be personally prosecuted. It isn't just the employers that get prosecuted. So that's just worth knowing. You needn't look very far to find out where companies have been prosecuted, though. You can usually find in lots of different places details of where companies have been prosecuted. So anytime anyone is prosecuted by the HSE, they have a public register of prosecutions, and you can go onto their website to find out details of companies who've been prosecuted, what they were prosecuted for, and information about the findings from that prosecution. Let's go beyond that, though, because it's everywhere in the media. If an organisation fails to comply with their legal duties, someone has an accident, someone's put at risk, especially if there's a fatality, it will typically make the media. So it isn't just the scrutiny of the HSE or environmental health or your own staff or your own stakeholders that you have to face. You also have the scrutiny of basically the public, because it could very easily result in the media catching wind of any criminal action or breaches in health and safety. Usually the bigger the organisation, the more public facing, or the more severe of an incident, the more likely it is that the media will catch wind of it. Okay, and as I said, we haven't got to look far to find information of prosecutions and criminal action. Let's just take a look at some of the prosecutions that we've had in 2019. Okay, so an interesting video, some very recent prosecutions in terms of, they're all from 2019, 10 of the biggest prosecutions in the UK. Notice that every single one of those all resulted in fines of £1 million plus, so well over £1 million, and not all of them for fatalities. So it's quite interesting. So you maybe, just as another example, one a bit closer to home. So Charter Housing, they're a Welsh Housing Association. They were prosecuted after 6 cases of hand-arm vibration syndrome were diagnosed following a health surveillance programme. The affected employees were all part of the maintenance team, and the investigation by the HSE also revealed that the organisation hadn't adequately planned its work, its method. It hadn't trained or informed its employees on their risks to their condition. They did not limit the duration or magnitude of exposure of vibration, and they failed to put into place suitable health surveillance to identify the problems at an early enough stage. So this is something that isn't necessarily an injury, it's we're now going into ill health. So it's a worthwhile case study to look at. And Charter Housing, they pleaded guilty because they had an absolute duty to assess the risks of vibration, to measure the magnitude and exposure of vibration, to ensure that they manage that risk, they provided health surveillance, and to communicate, to inform, instruct and train their staff. And they didn't do those things. So there was an absolute duty. They had no choice but to plead guilty to regulations 5, 6, 7 and 8 of the Control of Vibrations at Work regs. And the organisation was fined £100,000 in order to pay costs of just under £10,000 for ill health. So the HSE, your environmental health, are getting very hot on the health in health and safety. Very, very hot. Vibration, dust, and some of the other risk factors that we saw back in part 1, work-related, noise exposure. We're thinking about things like occupational asthma. So where we've got hazardous substances, if we've got hazardous substances that pose a long-term health hazard, perhaps they cause occupational dermatitis, those are ill health conditions that we have a legal duty to still protect our staff from. And we should be making sure that we get assessed, because otherwise we may be in breach of legislation. So let's just think about, we've got a fine of £100,000 here. In the video, we saw 10 cases where all of them were over £1 million in fines. Yet some were for fatalities, some were for injuries. So how does the sentence get produced? How does it get calculated? Well, in 2016, we had the sentencing guidelines, and they introduced a more consistent way of providing sentencing for health and safety, corporate manslaughter, and food safety offences alike. It has a tariff approach like environmental law does. And the way in which a sentence is governed and worked out is based on culpability. So how culpable was the organisation? How much of a hand did they have in the breach, in the incident? Obviously, then the severity of the incident comes into place, of the harm, and the size of the organisation. Now, one thing that is looked at in terms of working out how big a fine that organisation is going to have is its turnover, not profit, its turnover. So the bigger the turnover, the bigger the fine. And there are brackets in which those fines would relate to as well. And I'll be issuing you with a handout for you to see exactly what those sentencing guidelines look like in a bit more detail. It does have an element of adjustment to the economic reality of the organisation. So, for example, if that organisation is due to go into liquidation, that will be taken into account. However, only slightly. What we're tending to find now is that fines are definitely on the increase, and the risk of custodial sentences for individuals, so individual directors, individual senior management or senior personnel, we're definitely seeing a rise in that. So it's important to know that the organisation has legal duties, directors and senior managers have legal duties, and so do the employees. Where the organisation is seen as breaching its legal duties, we possibly fall into the elements of we could be prosecuted. However, an enforcement officer will, of course, look at other means of enforcement where we aren't looking at a fatality. So we could be looking at just an improvement notice. We could just be looking at a prohibition notice. It's only where it's severe enough or there's a really poor history of compliance where prosecution would be the first thing that an enforcement officer would jump to. And then, of course, if we are going down the route of prosecution, we need to think about the risks in terms of financial, because any fines that come out from a prosecution aren't covered by any insurance policy. There will be some form of cover, I think, if director cover is within insurance, but certainly this does have a big hit on the organisation. And then we need to take into account not just the criminal action, but what about the civil? So my background is health and safety, my background is enforcement, but I need to just relay some civil and obviously insurance liability case studies with you as well. So these are quite interesting ones because they're in relation to a lot of common risks that organisations have. So the first one, we call him Mr. Rowe. Mr. Rowe suffered a rupture of his quadricep muscle, which required surgery after he slipped at work. He's unable to return for several months and claimed to suffer psychological symptoms as a result of this. He was awarded £117,000 compensation. Second one, Mr. C was driving a forklift truck when a truck went over the hole, causing him to suffer back pain. Even though he had a pre-existing back problem, it was determined that the accident has caused an acceleration of that pre-existing condition. He was also dismissed from his job, but there was no other role available, and his compensation was £45,000. So quite serious amounts of compensation for relatively straightforward incidents that could happen in any organisation. And let's just not forget as well that a lot of the cost when it comes to an accident sits below the surface. So on average, approximately £40 billion is lost as a result of workplace accidents every year. Some will be covered by insurance, some not. So it's equated, the equation that's used here, for every pound that an accident costs you on the surface, that it's going to cost you between £8 and £36 underneath the surface. That's in terms of time, effort, resource to investigate the downtime. If there is a health and safety executive investigation going on, you may have to actually close parts of your business, certain activities. Plus, there's also other costs as well, such as increased insurance premiums. It could be also downtime of other people. There may be implications in terms of having to lay people off, etc. So cost of accidents isn't just the stuff that sits on the surface. It isn't just the time off that that person has as a result of the accident. It usually pulls in a lot more resource, time and effort and stress for the organisation. And then a final cost that we haven't really covered, but it is very important that we do. So I've mentioned that the HSE and environmental health are responsible for enforcing health and safety law. There is one vital difference between the health and safety executive and environmental health, and the difference is that the HSE sits under the Crown and it makes its money to fund its officers from the businesses that are failing in their duties. So your environmental health officers are based in local authority, and the council will basically pay for their wages and salaries. HSE is a little bit different. They make their money through the businesses that aren't complying. So as of October 2012, the HSE introduced what's called fee for intervention. So if the HSE identifies a material breach of the law whilst doing either an ad hoc inspection or an inspection on the back of a complaint or an accident, as soon as they identify a breach, a material breach of health and safety law, they can charge for their time. And let's face it, the lack of a documented risk assessment for a company that employs more than 5 employees is a material breach of the law, especially when that's linked to an unsafe workplace, no safe system of work. So where there is a material breach of the law, the health and safety executive, the enforcing officer, can charge for their time. And as of April last year, that's gone up to £154 an hour. And that doesn't just account for the HSE's time on your premises. It also accounts for any time when they're back in the office, doing any write-up, doing any back of house work, doing any investigation works. And that definitely is a fee that is not covered by any insurance policy. So £154 an hour can soon build up, because if we're talking about an ad hoc visit, okay, it could be there for a few hours, plus a few hours right up back of the office. When we're talking about an accident, they could be on site investigating for days, weeks, plus then all the time back at their office doing all the investigations, pulling together witness statements, etc. So that can become a bit of a blank checkbook to the HSE. So we don't want to give any opportunity for any HSE inspector to identify any material breaches, because if they do, we could fall under fee for intervention and that £154 per hour. So that sort of just concludes the legal, the main legal section before we delve into the corporate manslaughter part of this session. So have a think about just general health and safety, the risks that you have within your organisation that could result in injuries or ill health. Are we in breach? Are we fulfilling our legal duties? If you don't know what your legal duties are under certain regulations, find the approved code of practice, find the guidance, and make sure that you understand, because as directors and senior managers, you should understand what is required, what is in place, what risks you have, and what as an organisation you're doing about it, to make sure that you can justify to a HSE inspector or an environmental health officer when you get asked the question. Because it's very likely during an investigation, during an interview under PACE, that a director will be interviewed and you would be expected to know that information. So we've covered all the law when it comes to general health and safety and protecting individuals in terms of preventing injury or ill health. What happens when someone is fatally injured? So we're going to look at corporate manslaughter next, because as directors have a firm role in ensuring that health and safety is in place. And when it comes to a prosecution for a fatality, then a HSE inspector will be looking for, is there grounds for corporate manslaughter? So let's paint the picture a little bit of corporate manslaughter prior to the Act being brought in 2008. So prior to 2008, corporate manslaughter, as it was called, was possible for a corporate entity to be convicted of manslaughter, but it was important that the HSE was able to prove that the death of that person was caused by the gross negligence of an individual. So one person responsible. And that individual was regarded as sufficiently senior within that organisation and to be the controlling or directing mind. So when it comes to just general manslaughter, any prosecutor has to prove two things: guilty act and guilty mind. So that's where these two elements come from. You can prove guilty act very easily, because did they comply with the law, yes or no? It's very straightforward. And did that give rise to that injury? So i.e. there was no safe system in work in place, and that caused that fatality. Very straightforward in terms of guilty act. Guilty mind, however, and rare, is the part that's harder to prove, especially where prior to the Corporate Manslaughter Act being brought in, you had to be able to show that there was one person who'd been grossly negligent and one person who was the controlling or directing mind that then gave rise to that fatality. And if you think about an organisation nowadays, there usually isn't just one controlling or directing mind. There are usually other members of board, directors, management who have an influence, who play a part when it comes to making sure the health and safety is being managed. So corporate manslaughter was very difficult to prove before the Act. Corporate manslaughter, in terms of its penalties, has always allowed for the conviction of an organisation and an individual, but the individual has to be grossly negligent in order to prove manslaughter or corporate manslaughter. And the penalty for that was, and still is, unlimited fines. So how did we get from just general manslaughter to having one control and direct in mind to where we are today? So there's a few quite poignant accidents and fatal accidents that have happened prior to 2008 that sort of led to the way corporate manslaughter to be brought in as its own piece of legislation. The first disaster was the Herald of the Free Enterprise in 1987. So the Herald of the Free Enterprise was a roll-on, roll-off ferry which capsized moments after leaving the Belgian port of Zeebrugge on the night of 6th of March 1987. The cause of the sinking, or the immediate cause, was negligent by the assistant boatswain, asleep in his cabin when he should have been closing the bow door. But an official inquiry didn't just identify the assistant as being at fault because he forgot to close the bow door. They were actually supervisors at fault. There was a general culture of poor communication, and there were lots of issues identified that went a lot further than just the person closing the bow door. Unfortunately, the ferry capsized, resulted in 193 fatalities. These are just some of the quotes that have been taken from the sentencing hearing and from the prosecution. So it was identified that there were issues with management all the way through, from members of the board of directors all the way down to junior superintendents or supervisors that were guilty of fault. From the top to the bottom, the corporate body was infected with the disease of sloppiness, not having attention to detail, not making sure that things are happening. But because there was no one person who was the direct in mind, the control in mind, they couldn't prosecute anyone for manslaughter. 193 deaths, no one brought to account for manslaughter. So as well as the Herald of the Free Enterprise disaster, we also had the Piper Alpha explosion, which was an explosion that happened aboard an offshore platform. The fire, the explosion, caused 167 fatalities, and that was in 1988. Similar findings as the Herald of the Free, not just one person at fault, but faults and issues and just lack of control all the way through the organisation. Again, no one brought to account for that. It wasn't until the Lyme Bay disaster in 1983 that paved the way for a corporate manslaughter ruling. So Lyme Bay disaster was involving a small leisure facility that offered activities such as orienteering, canoeing, and on this particular day, there was a small college group that were taking to go canoeing. They were taken out by someone who was an instructor in the centre, and they came across very difficult waters, and out of the 8 children in the group, the teenagers in the group, 4 of them died. The ruling was that they hadn't assessed the conditions of the water that day. They hadn't taken into account the lack of experience that those 4 teenagers would have had. And as a corporate body, they were prosecuted. The managing director didn't really make sure that health and safety was being followed, implemented, everything's done that's reasonably practicable. And he was in prison for 3 years, and they actually tried to prosecute the manager of that centre because the managing director wasn't in an operational role. He would argue that the manager was the person who ran it day to day. The HSE tried to prosecute the manager just on a lack of evidence, were they unable to prove that. So they showed that they needed to bring something in because it wasn't just a managing director who was at fault. There was someone running that centre day to day, someone they should have been assessing risk, should have been making sure that people are safe, and that wasn't happening. It was showing that there wasn't one controlling mind. So the company was fined £60,000 and there was a prison sentence issued as part of that, but it paved the way for the corporate body and more than one person being involved when it comes to corporate manslaughter. So in April 2008, the introduction of the Corporate Manslaughter and Corporate Homicide Act was introduced. What the Corporate Manslaughter and Corporate Homicide Act does, it means that now action can be brought against an organisation instead of just one person, and an organisation where the manner in which it manages or organises its activities amounts to a gross breach of duty of care that then results in a fatality, i.e. someone's death has been caused by a gross breach in our duty to protect them. Corporate manslaughter can be brought where a substantial part of that failing was at a senior level, at a level where individuals have a responsibility for managing risk, and where it can be proven that there was a gross breach of duty of care that has resulted in a fatality, and those breaches have occurred at a level where management of risk should have been had. Penalties can be, as we've said before, unlimited fines, publicity orders and remedial orders. So a publicity order, excuse me, is an order in which you are required to make it publicly known that you have been prosecuted for corporate manslaughter, i.e. if the fine isn't going to damage your business, then the bad publicity will have an impact as well. Then you've got remedial orders. So if there were findings from the investigation of these were the breaches, but these are the things that need to be improved, then there will be a remedial order issued as well. So it could be an organisation is prosecuted, they are fined, but as well, they are ordered to put the following remedial actions in place to make sure that this doesn't happen again. Implications, well, if health and safety is being managed effectively, very little. The worry is if we have breaches of health and safety that are being identified, and there is also a risk that someone could die from an accident at work, then that's where the concern needs to be. Okay, corporate manslaughter is intended to cover the worst case scenarios of health and safety failures, and it will dovetail with the Health and Safety at Work Act. So normally when there's a corporate manslaughter prosecution, there's also a Health and Safety at Work Act prosecution or sentencing that's brought in with that at the same time. And we've talked about the sentencing guidelines. I just want to touch on how that reflects in terms of corporate manslaughter. So even though the sentencing guidelines were brought in 2016, there was an update in 2018, which outlined that convicted offenders should be sentenced in the following way. So if there's a case of gross negligence, there should be an increased sentence. So if it's been identified that the corporate body, management, directors, senior personnel have been grossly negligent, then chances are the sentence will be greater, and it can result into a prison sentence of starting from 4 years up to 18 years. Starting point from 12 years, where there was a blatant disregard or motivation to just avoid costs, i.e. health and safety was disregarded because it costs too much. It has to be in place to protect individuals and do all that is reasonably practicable. And we finish off the legal part of this training with this element. So my question for you as an organisation, is there anything, have you had any interaction with any enforcement authorities within the last 5 years? Is there anything that has come from that? I'd like to discuss that during our interactive session.